Hey guys, welcome back to my channel Immigration USA. This video we're going to talk about how to obtain a green card from B2 B1 visitor visa. It is possible through family-based or employment or investment or asylum and much more. We're going to break it down in this video, so stay tuned. Okay guys, so changing from B2 B1 visitor visa to a green card, it is possible, but there are different criteria and different avenues. So changing your status from B2 visa, tourist visa, to a green card or permanent residence, it is possible, but it depends on your eligibility and the type of green card you are applying for. There are different ways to obtain a green card, such as through family, employment, investment, or asylum, and each category has its own requirement procedures. One of the most common way to change your status from B2 B1 visa to green card is through family-based petition. This means that you have a close relative who is a US citizen or a green card holder who can sponsor you for a green card. However, not all relatives are eligible to do so. Only your spouse, parents, child, or sibling who can file for a petition for you. They must meet certain income and residency criteria. Additionally, there may be a long wait for a visa number to become available depending on your country of origin and preference category you fall under. So to break it more down, if you come to the US as a visitor visa, either a B2 or B1 visa, you can adjust your status while you are in the US, but you must wait 90 days from the date you arrive to the United States. After 90 days, you can apply for a petition or for a green card. If you have an immediate relative, such as a US citizen spouse or a child that is a US citizen and that is over 21 years old, that spouse or that child can sponsor you, can file an I-130 while you are in the US. They can file I-130 petition, I-485, which is the adjustment of status, and also they can file the travel documentation and the work authorization and much more. So that's only from an immediate relative, but you must wait 90 days after arriving in the US. If you apply within the 90 days, you're gonna get hit with misrepresentation, because they're gonna say that you say when you apply for the visitor visa, you say you're gonna come to the US for a visit. So within those 90 days, you're not allowed to apply for any immigration benefits, because you're gonna be hit with misrepresentation. Therefore, it is very difficult to obtain your green card. However, if you wait 90 days after, you can submit your application. So the petitioner can submit the I-130 and I-485 and some other documents, but that's only for an immediate relative. Even after the procedure gonna take a long time, so your visa gonna expire. The I-94, like the period that they stamp on your passport to stay in the US, is only 6 months. So after 3 months, you submit your application and you're gonna wait for a long time for the I-130 to be approved. Everything to be approved is gonna be more than a year. Therefore, you're gonna be in the US undocumented. However, if an immediate relative applied for you, all those stays, overstay in the US, work without no authorization, everything is forgiven. So it is easier to obtain a green card from an immediate relative, which is a US citizen spouse or a child that is 21 years and older. You can get your green card while you are on a visitor visa. However, if you come with a visitor visa and then you marry a green card holder, that becomes very hectic, because once your spouse that's a permanent resident submit the I-130 petition, the I-130 is going to take a long time to be approved. Therefore, you're going to be out of status in the US. Then you're going to have to go back home to start consular processing. So the best way to do it is once your spouse submit the I-130, you must leave the US before your 6th month is up. Then you're going to start cancel processing from your home country. But again, there's a wait time for those, such as the spouse of a green card holder or children under 20 of a green card holder. There is a wait time. Therefore, you're going to have to wait in your country until your priority date is current. And also F2B, I believe, is the children of 21 years and older of a green card holder. They also have to wait at home until their priority date is current, right? So that's the difference between the immediate relative and family preference. And also there's another one, the F4 visa, which is the brothers and sisters for US citizen. So you come to the US for a visit, and then your brothers and sisters apply for an I-130 petition. Then you're gonna have to leave the country before your visa expires. And then from that, they're gonna start cancel processing once your priority date is current. So those are long time. So then if you come to the US as a visitor visa and then you get sponsored by a family preference, and then you overstay your visa, then you still gonna have to go back home. And from home, you're gonna start consular processing when your turn is up. But at the same time, you're gonna trigger a 10-year bar, depending on how long you stayed here. If you stayed undocumented more than 6 months, you have a 3-year bar. More than a year, you have 10-year bar. So then it is not practical for a green card holder to sponsor you when you are in the US as a visitor. And there's another way to change from B2, B1 visa to a green card, and that's through employment-based petition. This means that you have a US employer who is willing to sponsor you for a green card based on your skills, qualifications, or achievements. And there are different types of employment-based petitions, such as EB1 for people with extraordinary ability, outstanding professors and researchers, or multinational executive or managers. And then EB2 is for people with advanced degree or exceptional ability. EB3 is for skilled workers, professionals, and other workers. EB4 is for special immigrants such as religious workers, translators, or former US government employees. And EB5 for investors who creates jobs in the US. And each category has its own requirement and procedure, and some may require a labor certification from the Department of Labor. Again, the employment visa is subject to a wait time as well, so which means that you may fall out of status while you're waiting for your priority date to be current. So the best way to do it and not to trigger 10-year bar or 3-year bar is that once you come to the US as a visitor, and then 3 months later, 90 days after, an employee can sponsor you, can submit a petition through the USCIS, and then before your 6 months is up, you need to go back home and wait for your priority date. In that case, you don't have any problem with the immigration. However, if you overstay, then it becomes more complicated. Then you may face 3-year bar or 10-year bar if you overstay. Then you're gonna have to go back and get your visa at home, and then that's gonna trigger not permanent bar, but 3-year bar or 10-year bar. So the best practice is that you come to the US and then you here 3 months. 3 months after, you find an employee that's willing to sponsor you, and that employer submit a 30 petition, then you should go back home before your 6 months is up. This way, you just have to wait for your priority date to be current, and then you begin the process. So you must check the visa bulletin each month at the State Department website. So they have a visa bulletin, and they tell you the wait time of each category. employment and also family preference category. So they have the visa bulletin available each month. So the third way to change your status from B2 visa to a green card is through investment. So if you have money and you want to invest in the US, open up a business and then have US citizens working for you, it is possible. So this means that you invest certain amount of money in a new commercial enterprise that creates or preserves at least 10 full-time jobs for US workers. And the minimum investment amount is $1.8 million. So if you have that amount, you can get a green card, come to the US, open up a business, and you must employ at least 10 full-time US workers. Or if the enterprise is located in a targeted employment area, such as a rural area or an area with high unemployment rate, then the requirement is only $900,000. But if it's in an urban area, it's $1.8 million. So this is also known as EB5. That's the EB5 category program. So you can get a green card simply by investing in the US. And the fourth way to obtain a green card from B2, B1 to green card, it is through asylum petition. This means that you have well-founded fear of persecution in your home country based on your race, religion, nationality, political opinions, or membership in a particular social group. You must apply for asylum within 1 year of your arrival in the US. After 1 year, you cannot apply unless you can show changes or extraordinary circumstances. If your asylum application is approved, then you can apply for a green card after 1 year of being granted asylum. Regardless the type of green card you are applying for, you must file Form I-485, that's the application to register to permanent residence or adjustment of status with the U.S. Citizenship and Immigration Services, which is the USCIS. You must also submit the required documentation, fees, and biometrics, and attend an interview if applicable. You must also ensure that you maintain your lawful status while your application is pending. So this is based on the family preference, right? So which is impossible to maintain because the process to obtain a green card takes a long time, so you're gonna fall out of status. However, if you go back home before your 6-month validity period is up, you can obtain your green card, but you would have to wait for your priority date to be current. And you also must not engage in any activities that could make you ineligible for a green card, such as working without authorization, committing a crime, or violating the term of your visa, and much more. So, if you commit a crime while you're in the US on a visitor visa and you commit a crime, you're most likely not going to be able to get a green card. So you come to the US, you want to settle here, so you must be a good person with good moral character. So you must not have any criminal history, and also you must not work without authorization, especially on the family preference. However, on an immediate relative, as I mentioned before, even if you overstay your visa in the US, you're still going to be eligible to get a green card because all that overstay and work without no authorization is forgiven. So overall though, when you come to the US, you want to get a green card here, you want to stay here, you must consult an attorney, immigration attorney that's very knowledgeable, so they can guide you through the process and give you all your options and advise you how to proceed, whether you should stay here if you have a immediate relative sponsoring for you, or if you have a family preference relative sponsoring for you, you need to go back home and start your consular processing, and that takes time because you need to wait for your priority date to be current. But it is a safe way to go back home before your 6 month is up. But if you stay more than 6 months, then it gets more complicated. You're most likely not going to be able to get a green card. But unless you have an very knowledgeable attorney. In some cases, you need a waiver because you misrepresented yourself if you apply within the 9 days of your arrival. So you must wait 90 days after you arrive to the US and apply for a green card, which means that your sponsor will submit the I-130 petition and then take it from there. So that's it, my friends. I hope you guys enjoyed this video. Please don't forget to subscribe to my channel and smash that notification bell for more videos. Thank you for watching. Bye-bye.